Well, hello everyone. It feels like morning to me for some reason, so I was ready to say good morning, and then I remembered it's 2 p.m. Eastern Standard Time. So good afternoon, everyone. Sorry, I wasn't able to follow the chat. I was still doing some last minute highlighting. I had gone through these motions just with my pen and like had all my scribbles everywhere. But I like to go through and highlight what I'm going to talk about, what's going to be on the screen. So I was rushing to do that. And I have to say, we have the hearing tomorrow, and normally I'm really excited about the chance to listen in. But historically, these hearings have been so rage inducing that I'm not looking forward to it at all. Because I feel like we all know, and from what I can see from what you guys have been typing, I think we all kind of have this like feeling of dread because we know how it's going to go. To me, a hearing in this case is just so that Judge Lyman can cut Wayfarer off and not let them finish speaking, not let them say what they came to say, and then to step in as an extra lawyer for Blake's team. Because if they miss anything, then, never fear, Lyman steps in and starts lawyering for them. And it's so rage-inducing. I know you guys saw that before, that he just cuts Wayfarer off. And there was one time we didn't get to actually listen in, so we didn't get to hear it. But even like reading the transcripts later, you could see all the times that Wayfarer starts talking, no matter who's speaking from Wayfarer, and they get half a sentence and they get cut off. Meanwhile, Blake's attorneys get to just keep rambling on as long as they want to. And if they miss something, never fear, he's going to come in behind them and clean it up and be a stand-in attorney for them. Thank you so much, little Coco. Thank you. So I feel like that's what it's going to be. Yes, BPX, he does. Lyman acts like he's one of her lawyers. He cuts off Wayfarer's lawyers. And it's just sad because he's the one, he's supposed to be the referee. He's supposed to listen fully to each side, tell their side, present their case to him, and then rule. And that's not what he does. That's not what he does at all. He doesn't even let them finish speaking. So he doesn't even know, in fact, when he makes his decision, he doesn't even know what they came to present because he's not allowed them to present their case. It's just infuriating. I was going to go back through, but I thought I'm just going to get this out because I have a couple of errands to do this afternoon. But yeah, what I had intended to do was go through and find those transcripts and those bits of hearings because we can't record them, so I will get them transcribed as quickly as I can. And then sometimes, the transcriptions do come up, they do show up later in the docket. So we get them, but I was going to go through and find all the times that he's cut them off and the times that he's lawyered for them, but I thought it's going to make me madder than I already am. So I didn't do it. But if this one goes that way, that's going to be a project of mine. I'm going to go through all the transcripts of all the hearings in this case and highlight every time he's cut off Wayfarer and every time he's lawyered for Blake. Lyman, you almost killed me. Bushburns, Lyman and Lively sitting on a tree, or like here in this little picture, sitting on his lap. Thank you so much, Just Ricardo. Judge Lapdog is well trained. What's next to she use? What are those commercials where it's bacon and the dog's like running? Bacon, 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 bacon. She must use bacon. Oh no, I think he wouldn't eat bacon. So I don't know. Turkey bacon. Let's see. But oh, what's this? Robin's in the house. Anyone read the story of how Blake got her first movie role? That's interesting. I would like to hear that story. I know the stories of when she made a movie with, what's his name? He was married to Jennifer Garner. Fakin. Roman says Fakin. Instead of turkey bacon. Yeah, I don't eat that stuff. But have you guys ever had beef bacon? It's made the same way, but it's made out of beef. There's a butcher, a local butcher that makes it. Ben Affleck. That's right, Gigi. Thank you. Oh, and everybody's going, Ben Affleck. I just saw everybody. Thank you guys. But yeah, this butcher makes it out of beef and it's so yummy. You've had it, Hans, isn't it? It's so good because it's made exactly the same way, but it's a higher quality of meat. So it's amazing. It's so yummy. Okay. So we're going to talk about this whole document 834. Now, before we get into it, I did a little research. Probably should have done a little bit more, but I'm like, this is good enough. So here's the truth about a motion for judgment on the pleadings. It is not something that's a time waster. It is a time saver. It is just like a motion to dismiss, but it comes later. So what it can do is it looks at only the law. It does not consider evidence at all. The rules of it are basically a motion to dismiss, but a little bit later. So if there's something wrong with your pleadings legally, if they're not legally sound, they get marked off. Well, that saves everybody time, especially the judge, because he can just go through and get rid of all the unnecessary yuck. And it made me think, I have a friend who was a manager of a hotel. And one of the banes of their existence is that when housekeeping calls off, because housekeeping, to be honest, is what makes the hotel go round. So if they don't show up, you don't have clean rooms. You have a disaster. People come, they're trying to check in. You don't have the rooms clean. So what they will have to do in that situation is everybody has to go help clean. And there's something they do, and I couldn't for the life of me remember what she called it. But it's someone will come through and will collect all the garbage, collect all the dirty towels, collect all the dirty bed linens, and basically strip the room. And then the cleaners who are there just have to come through, do the actual cleaning of the bathroom, and make the bed, put the new linens, vacuum. And I can't remember what that step was called, but it could save the hotel hours worth of work for the housekeepers. And was it called stripping the room? Something it was called, so people would go through and do that, and it would end up cutting hours at the end of the day off of the cleaning. And this is basically what this motion does. It's not a bad thing. The courts actually love it because it gets rid of a lot of unnecessary stuff. It clears it out and it leaves just the necessary bits that need to be argued at trial. So all of these arguments about it wasting time are so ridiculous. Glow says, Blake is a Weinstein girl on the couch. I've seen her and her husband fawning over him. And I know she defended him, so I would not be surprised about anything. So basically, they can go through, and if the things are not pled in a legally sound way, they're just marked off. It's that simple. It's good for everybody except who's losing their things. Wayfarer lost all their stuff in motions to dismiss. They know the feeling. Blake didn't have a problem with that. She cheered that on and did a whole victory tour. But now when she's facing something similar, oh my goodness, it's the end of the world. So these are the cases I looked up. So we have Perez versus Wells Fargo Bank. 4 months before trial, this was allowed. We're 5 months before a trial as we stand. So obviously this isn't a problem. It's not the big deal they're trying to make it out to be. Then we have Aponte Torres versus University of Puerto Rico. This one, because another one of her arguments is that it's so long after the complaint and the answers. Well, this one was filed 9 months after the amended complaint. She just had her second amended complaint in July. We're not that far from it. So that argument, moot. Then we have a couple of Southern District of New York cases. George versus County of Westchester just a few years ago. This could have been Liman for all I know. I forgot to look, but he was a judge by that point in the Southern District. They granted the motion 4 months before the trial. And the judge noted that this kind of motion is designed to resolve purely legal questions efficiently. This is not designed to go through any evidence at all, like they're trying to present it. And the last one, Bank of New York Mellon versus WMC Mortgage, less than 5 months before the trial. This was allowed, and the judge in this case said that it's not disfavored merely because trial is approaching. So, according to case law, there's no reason for him to rule in their favor by what they've presented in this motion. Does that mean he won't? No. And I'm all set for him to rule in her favor, at least in part. So that brings us to this motion 834. So, and here's my big question before we get started. If her pleadings are so legally sound, why is she so worried? If she feels good about her case, and she's had an extra amendment that Wayfarer never got. So how many tries has she had? She had her CRD complaint, may or may not have had an EEOC complaint. Then she had her first lawsuit, and then it all got moved to the Southern District. She's had a first amended, a second amended. She's had plenty of chances that if there was something she didn't feel right about in her pleadings, she could have fixed it. So why is she so concerned? If you feel good about your case, if you know that your case is legally sound, all your pleadings make sense, you wouldn't be sweating this hard. So what's the big deal, Blake? Oh, I just bumped it. Sorry. So what she's asking basically to take away their right to file this motion. They have every right to file this motion, but she wants to take that right away from them. And in the alternative, was she saying, forget it, let's just go for summary judgment, because summary judgment is a bigger deal. They go through evidence and stuff. And it gives her more time to try to scrape together a case. And then as an alternative, if the judge doesn't rule in her favor, fat chance of that, she wants to move for an extension of time all the way to October 27th. All the way to October 27th. Gina says, I'm pretty sure Not Actually Golden said the judge can't just dismiss her motion. The most he can do is give her the extension she's asking for. He can also move it to a summary judgment. That's one of his options. And that's one of the things she's asking for. Not Actually Golden explained why the motion for judgment on pleadings couldn't have been filed before August. And I agree with that, but that doesn't mean that this judge is going to recognize that. This is all at his discretion. And she has no right to even ask for an extension. How many times? This is another thing I wanted to look up and I didn't because I knew it was just going to make me mad. How many times have they been absolutely nasty when Wayfarer has asked for an extension? From the very beginning, when Brian Friedman's house was literally in flames, and was his office in flames too? I can't remember. But it wasn't like he could just run to the office. Los Angeles was burning. And they protested his request for an extension. And then later they're like, well, it's not our fault. They can't keep their calendar in order. That's another thing they've said. When they were when they set up their person to depose for 9 o'clock, and then Blake comes in last minute and wants to move it to 8, and Ellen has other things she has to do because she's the one who set up the appointment and set it up for 9. They were like, well, send more attorneys from your big old law firm to go fill in. This is the attitude that they've given when Wayfarer has asked for something. And then they're like always asking for themselves and expecting the court to do something about it and saying, oh, this will greatly prejudice Blake. And he always rules in their favor. But they can't do this ever for Wayfarer. And Mashante says he can't even do that in full. At most, he can give her an extra week or so. He'd have to move all the deadlines, including the trial, if he gave more than that. Yeah, doesn't mean he won't. Oh, we'll see. We'll see what he does. Yeah. Yes. Lyman's wife needs to investigate why her husband is so favorable to BL. Exactly. Yeah, that's how I feel, Aurora. He will allow whatever Blake wants. I just feel it. I just feel it. And yes, she does. She has a pattern of wrecking homes. Okay, the call-in info, I see some of you asking, Holly asks, where do we find the call-in? I don't think they've posted it yet. Not that I've seen. He said he would be posting it. So we just have to keep an eye out. I'm sure everyone will have it posted. When I hear of it, I'll put it in my community tab, and I know a lot of others will. I know people like Leanne and Don't F with Justice on X, they will for sure post it. We'll find it. Glow loves books. Thank you again. Wayfarer should agree then to post Taylor Swift. Yeah, that was the other thing. There was no extension offered for that, even though that greatly prejudiced Wayfarer's case. He sure didn't allow that, did he? But she got to extend the deadline for depositions to do all of hers. It's so ridiculous. Enrique asks, Cassidy, is it okay for him to take so much time to rule on stuff, but not for Blake's side? All of this is at his discretion. Is it morally right? No. But the court is completely in his control. Now, all of these things, they can keep a record of it and use it for an appeal if they lose. But he's not officially doing anything wrong. That's what's so maddening about the whole thing. Yeah, I've heard this argument, Robin's in the house. Some attorneys say he's giving her everything to prevent an appeal by her. And I've said this so many times that I would believe that if he wasn't so obviously nasty to Wayfarer. If he was treating them both nicely and fairly, but was giving her these favors, but still being equally nice to Wayfarer, I would say, yeah, that's a possibility. Or even a probability. But it's not. Yeah, I agree, Mashante. Sorry, I know I just destroy your name every time. I think Wayfarer is just like, whatever, who cares? We're tossing this and appealing our case since the judge won't even won't allow even kind of fair discovery for their defense. I would feel that way at this point. I would. I would be beyond angry tears. I would be like, we're going to get through this and we're going to appeal to a different judge. But okay, let me get back on track here to where we are. And then he says Miss Lively's prepared to respond, and you're like, oh yeah, well then why is she fighting? And then you read the rest of the sentence. At the summary judgment stage or at trial. So again, they want to absolutely rob the Wayfarer team of their right to file this motion. And that's wrong. That's why I put that in the title. That's part of procedure. She doesn't have a right to rob them of this. Yeah, Jane, you have to rule according to law, not emotions. Lie dog. Lie dog. He's got so many nicknames now. Okay, then it says the Wayfarer defendant's decision to sit on these supposedly meritorious arguments for nearly 9 months means that briefing and adjudicating them now would only lead to duplicative briefing and waste judicial resources and would force Miss Lively and the court to bear the burden of the Wayfarer defendant's delay. Are they not allowed to use strategy? Who are you to say that because they decided to wait, that it's a bad thing? They have every right to use whatever strategy they want to use. And how will it be duplicative? It's that simple. They file it, the judge rules on it. How is that duplicative? He rules on it and they're gone. If you want to fight it, that's your business. But that's not a duplicative briefing, and that's not wasting judicial resources. And it's not burdening the court. It's saving the court a lot of time. And then then he admits that Wayfarer alluded to the possibility that they were going to file this. So you've known since July 30th, and here you are admitting it. You should have been ready. And you know what else? You filed, like I said, a second amended complaint in July. Why didn't you make your pleadings stronger? We're going to get to that. I got a little ahead of myself with that. And then waited to file their motion until the response deadline would fall on the last day for depositions in this case. What about that omnibus motion to compel? We all remember that when she dumped that huge motion that she had that in the works for a long time and could have released it little by little, but plopped it down at very bad timing for Wayfarer. Do you guys remember that? They asked for an extension. They fought it with nasty, nasty words, and the judge ruled in Blake's favor, and they had to deal with that at a very bad time for them. Do you guys remember? So why are moves like that okay for Blake and just the end of the world and unfairly prejudicing for Blake's team? It's crazy. And then it says, knowing full well, because of their own discovery deficiencies, Miss Lively's counsel would be so. But before we go on, I want to point attention to this footnote, because there was a thing about Blake not naming It Ends With Us movie in her CRD complaint. And now they're saying that she amended her complaint and received right to sue letters with respect to It Ends With Us during the pendency of this action. Have they not produced those? I've never seen them. And if they did that, they would have had to ask the court's permission, or at least introduced it to the court. And I don't remember any of this happening. And I'm pretty sure Wayfarer would be aware that this happened. So when did she do this? You don't just run off and do that and then not inform the court that you've amended it. Yeah, you can go amend it. The California The civil department is very, very lax about letting you amend it. But the thing is, if you have a lawsuit already in motion, you have to bring that amended complaint to the lawsuit and at least inform the court. So when did this happen? And then they talk about how, oh, we're going to be so busy taking depositions. Well, what did you tell Wayfarer when you changed the time of their deposition? Well, send one of the many attorneys from your big law firm to cover for you, right? How many attorneys does Blake have? And how humongous are at least two of those law firms? Humongous law firms. Manette and Wilkie Farr. Huge. So what's the problem, Blake? You've got way more attorneys than Wayfarer does. You can't handle all of that? Why'd you wait so late to schedule your depositions? And saying, oh, it's Wayfarer's fault because they didn't supply blah, blah, blah. You don't have to have every piece of discovery before you can do a deposition. You can do it earlier. And then a lot of times after you do the deposition, you find out you need more discovery. And if something big comes up later, and you're like, oh, I wish I could have asked that in discovery. Guess what you can do? Or not discovery, in deposition. Guess what you can do? You can have a quick little added deposition if you need to. So she didn't have to put all these depositions off to the last minute. While she was busy sending out a subpoena to 107 content creators to get absolutely nothing, she could have been filing motions to compel, and so she could have gotten her stuff earlier. She could have been holding some depositions. This is all her bad scheduling because she was desperate to try to find something and subpoenaing people like me. What did that get you? All right, getting so mad again. So anyway, where are we? The question at this stage of the case is not what the pleadings allege. Who says? Who says? You? Because you say so? But what the evidence shows, no, it's not. The evidence is not evidence yet. Right now, it's just discovery. It becomes evidence later. It is not evidence now, and this is not the time that you consider it. And the appropriate means of answering that question is through a motion for summary judgment. We are not in summary judgment yet. You don't just get to take this motion away. The Wayfarer defendants will suffer no prejudice from a few weeks' additional delay in briefing those issues. Yes, they will. You will take this motion that the court has allowed, that the federal government in their rules has said you have this right, and you want to take it away, and then you want to say they will suffer no prejudice. That's absolute nonsense. Absolute rubbish. And then here's the point. We're going to keep this in mind. I said this earlier, got ahead of myself. Miss Lively filed her second amended complaint on July 30th, 2025. Keep that in mind. And then he goes on, this next paragraph's there was nothing even in it to highlight. He just kind of goes through history of all this. Who cares? I literally put in the margin, so that was or no, not so, what did I put? And like, what's your point? And then so he says early enough not to delay trial. What about doing this now is going to delay trial? It's 5 months away. What How is this gonna delay? The judge just has to sit down, look at it, and see if these things are legally sound. It's actually not that hard. He doesn't have to consider any evidence at all. He just has to look at that motion that Wayfarer filed and look at the response that Gottlieb filed and decide. It's quite simple, actually. And things like the California law, extraterritorial, he doesn't even have to dive into law to decide that. That's very simple. Thank you, Just Ricardo. With each word written, I hate these people more. Me too. Me too. I feel so disgusted. Just like it actually makes me feel nauseous. Okay, and then he says it again. Early enough not to delay trial. It's not going to delay trial. How does it prejudice the the movement? If your pleadings are not legally sound, they're not legally sound. And if you don't like that, that doesn't mean it's prejudice. It just means you didn't do your job. And if you did your job so well, why are you this worried? And then he says the courts are unwilling to grant a judgment under Rule 12.6 unless it's clear that the merits of the controversy can be fairly and fully decided in the summary manner. What about these arguments that a California law cannot apply in a federal court in New York would be unfairly decided? That's either true or it's not true. There's nothing you can do to make that true if it's not true. And then again with this untimely, the arguments raised have been available to the Wayfarer defendants since the initial complaint was filed. And it was there for you too. And if it wasn't, in fact, if it didn't have merit, why didn't you fix it in all of your amended complaints? And then he says the arguments are meritless. Well, then what are you worried about? He says they're all but moot. Then what are you worried about? And then we get to this. And this really makes me mad. Miss Lively has uncovered voluminous evidence relevant to all of her claims. Yeah, right. Rather than merely defend the sufficiency of the allegations to respond adequately to the motion, Miss Lively would also need to make a proffer of the new and more detailed facts in her possession that would entitle her to amend her complaint. So this is what they want. This is what it comes to. So if the judge rules and grants Wayfarer that these pleadings are without merit and dismisses them, this is what she wants. She wants a chance to amend her complaint, which he doesn't have to offer. They can ask for a reconsideration, but they don't automatically get that chance. But this is what makes me mad. Two things. One, on July 30th, in order to keep Jed Wallace in this lawsuit, she filed a second amended complaint. That was not that long ago. She changed nothing except trying to prove that Jed Wallace knew she was in court. And as you guys know, my most favorite piece of evidence showed up there. The picture of her standing, posing in her little jeans, saying blue jean baby, New York lady. I mean, the most riveting piece of evidence I have ever seen. I was ready to say she wins the whole case when I saw that picture. But my point is, instead of taking pictures of herself on Instagram to prove Jed Wallace knew she was in New York, why weren't they fixing their pleadings? They had this extra chance 2 months ago to make sure all of their pleadings were sound, and they didn't touch anything except the bit about trying to keep Jed Wallace in. That's their fault. She had a chance. Now she's talking about a proffer. This is like additional evidence that you present to the court. Why didn't you do it then? Why didn't you do it then with all your voluminous evidence? And you know what? The second point that makes me so angry is is the way Wayfarer's claims got removed before he got to get all of his evidence. So this same argument that they're making, what about all the voluminous evidence that Wayfarer could have gotten through discovery that was denied them? Right? Why is it the end of the world for her? But what about Wayfarer? And then she mentions the March 2025 trial date and conducting that exercise only once. So they get two chances. They get this, and they get, if anything doesn't make it on this one, they can present it again at summary judgment. It's not supposed to be only once. Both of these motions exist, and one doesn't cancel the other. You get a shot at both. So their arguments are so stupid. It is not duplicative. And if it's duplicative, it's because they get to serve both of these motions. And the first one doesn't involve evidence. It's all about your legal pleadings. And then they say again, the Wayfarer defendants will suffer no prejudice. That is so false. Because what they don't get dismissed in this motion, they have to turn around and fight again in summary judgment. That means a much bigger, more strenuous argument. How is that not prejudice? How does that not prejudice them? That's such a false statement. Miss Lively will suffer significant prejudice from having to file what is effectively an opposition to summary judgment while discovery is still ongoing. That's what you have to do when your pleadings get denied. That's what you have to do. That's what everybody has to do. Blake Lively is not special. And you've got how many attorneys? How many attorneys are working this case? I think you can handle it. Miss Lively will have to scramble to amass evidence from a discovery process that is, I thought you had voluminous evidence that is and will be generating new evidence virtually every day between now and the response deadline, including depositions of Mr. Baldoni, Mr. Heath, and Wayfarer, Mr. Sarwitz, Miss Nathan, and Mr. Wallace, not to mention expert discovery process that will still be ongoing for several weeks afterward. Like you said earlier, it's not our fault you can't manage your calendar. Why'd you put it all off? Glow loves books. Just like the OJ lawyers all got bad karma, so will Blake Lively and her lawyers. Can't happen soon enough. But Tiffany says that her mom told her she was special, so it must be true. Oh my goodness. I've been seeing so many funny things people dig up on Instagram in the reels. There was one where she's on with her mom about something, and now the story was that her mom sewed all of her clothes. She got her fashion sense from her mom because her mom sewed all of her clothes. I'm like, yeah, sure. Sure she did. Sorry, I'm looking at the chat real quick. Cynthia asks, can Wayfarer make an appeal right now? I'd rather start all over again with a fair judge than go through this with Lapdog. I think they've got something big with Van Zandt in the works. I just have that feeling. So I think we just have to be patient. They just had the Van Zandt deposition a couple days ago. So I think their summary judgment is going to be wild. Oh, thank you, Sorty. My voice is soothing. I feel like I'm screaming and nasal today. Yeah, she was born with no empathy and no guilt, and that's how she continues when most people couldn't. She wasn't blessed with those emotions. I agree, Robin's in the house. Some people really don't have those things. She's a walking, talking contradiction hairball, says Girly C. Yep. And Claudia says she's a compulsive liar, in my opinion. Absolutely. Oh, did he? Oh, I haven't seen it yet. Thank you. SGAX says Brian Freeman responded regarding New York Times suing. His statement is so good. Oh, I can't wait. If you guys followed me from the beginning, you know how big a deal the New York Times thing was to me. I did so many episodes about that before I even dove in to the actual harassment part of the case. The New York Times was a big thing for me. I was devastated when they got, I mean, I knew they would because they're just so well protected in New York. But I don't know how they're getting away with filing a secondary lawsuit when they're still named. They've not been released. I mean, I know they were granted the motion to dismiss, but their name is still affiliated with this case. How can they go make a whole different case in a different court? Normally that stuff all gets consolidated together. So I didn't get to deep dive into that, but that's a big question I had as soon as they saw they're filing this in New York State, and they're filing it in New York State court because New York State court allows anti-SLAPP and federal court does not. So it's basically forum shopping. But how are they able to do that when they are still a part of an open case? Normally that stuff all gets consolidated because Wayfarer's case against the New York Times was out of California and it got consolidated to this case because that's what happens to keep everything consistent. They all get removed to one court. So why are they allowed to go file this case in state court to forum excuse me, to forum shop because they can't do anti-SLAPP in federal? On civil law says it should be consolidated. That's what I thought. That needs to be moved, but right back before Judge Liman. But they're doing that so that they can get their anti-SLAPP fees. And it's so low down dirty. After what they did to these people, they have no shame. Roman says, isn't that funny? Gottlieb is saying he wants to present evidence, but Ezra saying no evidence. No rule now, Judge. They can't even decide what they're doing. They're just a big old mess. You know they're sick to death of Blake and Ryan, but they're not sick to death of billing them. Exactly. This is my whole thing. Mashante says New York State Court allows anti-SLAPP, but it was a federal and not a state case. In federal court, you need to file a Rule 11 motion for sanctions, not this lawsuit. I agree. I don't know how they did this. Yeah. I wondered about that. Apparently, New York Times has never sued anyone for fees after a lawsuit was thrown out before. I don't know why they're doing this crazy thing now. It's insanity. What they did was unbelievable, and they have the nerve to come back and do this. Okay, where was I on this one? Let's get back to this. So they ask again that the court deny the motion or hold the motion in abeyance until trial. Why you don't have a right to deny them of something that the federal rules of civil procedure grant them. What do you think this 12.6 is? These are the federal rules. The federal rules say you have a right to file this motion. Blake Lively does not have the right to take authorship of the federal rules of civil procedure. She wants the extension all the way to October 27th. Outrageous. The current response deadline is October 10th. She has 8 days. Why is that so awful? Some of these things, they have like 2 days. The judge will give them 2 days to respond. And she's crying about, she's got 8 days left. So days have already passed, and she wants till October 27th. That is outrageous. All right, then we have this one. I looked at the scheduling order the other day, and I'm like, oh, they missed this. And so this is what it's about. And this one will be granted, and it should be granted. So what they forgot, did I include? Yes, I did. Okay, this was the revised scheduling order. So here's what was missed. These requests to admit. And I just saw this the other day, and I was like, oh, they missed that. So requests to admit, this is done after a good portion of discovery has been done. The depositions have been done. So the original date was August 14th because that was supposed to be the end of depositions and the end of fact discovery. So what this is each side, they take and they say, basically, would you agree? Would you admit to this point, this point, this point? And see what the other side is ready and willing to admit to. And so each side submits this document to the other side. They have to answer it, return it, and then each side knows what the other side is going to still fight at trial, so that they know exactly. So there's no guesswork about what they have to prepare or not prepare for trial. So, I just saw a comment that I agree with. So this never got changed, this date, and it would have had to have changed. So that's why I think the judge is going to grant this, because there was no way they could have even put this out then and answered it, known how to answer it at that point. But it just was a matter of it got overlooked. So they're asking the court to update that because that date never got updated. And so there shouldn't be, everybody should want this because they all missed it. That was, a couple weeks ago. So it was just something that everybody missed, including the court, and it just needs a new date put in, a new due date put in. And there's nothing wrong with asking for that, and there's nothing wrong with granting that. The only thing I couldn't stand was Miss Lively will suffer prejudice in being unable to obtain admissions from the defendants across a variety of issues that await party testimony. Everyone will, not just Blake Lively. Roman says, I think the New York Times is afraid of Van Zandt. I think so too. That's when they rose up from the dead and came and started demanding to be released from this and then doing this. I really think so too. They never had to submit any discovery to the court. They filed a motion for stay of discovery and it was granted. So they didn't have to provide anything. So if they advised, see, here's what I've always thought happened, that Blake ran to the New York Times and said, I have this story. Look at all these text messages. Aren't they shocking? And the legal department probably told Meghan, how do you have these? You have to prove you legally have these. And Meghan probably told Blake, you've got to legally have these. And I think that's what started the whole Van Zandt thing. But the second point is this. If you bring this stack of messages and you say, I got these by a subpoena, and you want this newspaper to print them, that newspaper, or at least their legal department, would, or at least should, ask to see that subpoena or that lawsuit that they came from. Now, we've seen that lawsuit. We haven't seen the subpoena yet, but we've seen that lawsuit. So if you look at that lawsuit and it says Van Zandt versus Doe's 1 to 10, and it's a breach of contract, and then you have all these people's private text messages, even someone who's not well versed in law, alarm bells would ring. Like, what is this? How did this allow you to get that? And the New York Times has a huge legal department. They would have known at first glance that something was wrong with that, but they allowed all of that to be put in there. And I always come back to, because they are protected under privilege, that's true. And the privilege that they're protected under is that they can report on judicial proceedings. Now, in New York, where they've extended protections beyond the Constitution, they consider something like this private CRD complaint to still be, documents are considered judicial proceeding. But Just Khaleesi's got it. This is the part that drove me crazy. In that newspaper article itself, it said the complaint, and it said thousands of pages of text messages and an email, something like that. So they admitted that they didn't just go by the CRD complaint, because guess what? The CRD complaint was not thousands of pages. So they were obviously, and by their own admission, that article was written off of these thousands of pages of evidence. And then Leanne found in the metadata that they had that stuff back in October, months before CRD complaint was filed. So they did not have a judicial proceeding to base that article on. And the article comes out hours after she filed that CRD complaint in California. It's impossible that that CRD complaint was filed and that they sat down and wrote it. So everything about what they did was not right. How they got away with it is just insanity. But I think that's what they're worried about, because as soon as Van Zandt started to come back into the picture and they realized they're going to move on this, that's when they freaked out and they want released from this and they want this lawsuit. To me, that's the only thing that comes through to say why they're doing this. Thank you so much, KKB. Do you know where we can find the hearing call-in number? I'd like to listen in on this one, but I have no clue where it will be posted. So the court will post it. And it gets posted, it gets pretty well posted everywhere. I know they will on X. I'll post it in my community tab. Probably a lot of other content creators will. You can look for Roman, who's here in the chat, I know will probably post it. Mashante probably will post it. Leanne will post it. Don't F with Justice will post it. It will probably be on Reddit. I'll put it in my community tab too, but to my knowledge, it's not been posted yet, but it will be put on the docket. But yeah, those thousands of, I will always feel that was wrong, that the New York Times got away with that. Even how they keep things in New York is so wrong. They don't go by, everywhere else goes by the plaintiff and where they felt the damage. That's the choice of law. But New York has made their own rulings to get around it. And so that it will always be in New York where they can control it. It's like mafia. It drives me crazy. I don't know why it's allowed. I wish the Supreme Court would hear a case and overrule that. But yeah, so that's this second thing. So now we're waiting. Wayfarer's response is due today to respond to this mess, and then the hearing will be tomorrow. And we'll see how it goes. But I'm excited to go read Wayfarer's response to the New York Times, and I can't wait to read the response to the Wayfarer's response to Michael Gottlieb, who's, and I have to say again, I said this when I went over the last one, but Michael Gottlieb's, his response was pathetic. It's not really based in, you're supposed to prove your case by the law, not by whiny complaining. These are like crybaby filings. They don't even really give the judge anything to work with other than this deeply prejudices Blake. It drives me crazy. But yeah, this was my thumbnail today. Get in there and fix this whole because I feel like they tell him what to do and he just does it. And then I created a new magazine today called Insufferable. And inside this issue, what happens when the law firm is even whinier than the client? And there's some side articles in there. Is Ryan tired of paying Blake's legal bills? And Blake reportedly not worried about upcoming hearing. And we have her sitting in his lap, and it's kind of zoomed out, but her little button on her blouse says, Daddy's Girl. And I forgot what the mug says, something like number one dad or something like that. I can't remember. Okay, Bella says, I think Gottlieb was drunk when he drunk and crying. That's what I picture, just sitting there drunk and crying. Daddy Chat GPT, like Perez calls it. Mint Agave says Michael is angry. Indeed. Ryan wrote them. You know they sit there and make them write stuff they don't want to write. I will always believe that. Mama Datia says, hopefully they know they're screwed and angry that the new lake house may not get a pool. Mashante says, I would be drunk crying if at this point I realized I didn't even sue the right company. Yep. It should say insufferable Blake. Yes, Jessica Lisi. All right. Girl on Fire says, I wonder if Justin has more flirty texts from Blake. I think she tried. I wonder. Wouldn't that be funny if a bunch of those show up in court? I wouldn't doubt it. Yeah, and he didn't fall for it. Whether she uses teeth or not, he was not into that. He's all about his wife. And I'm sorry, but I've seen clips of them on X and Instagram, and they are the most adorable. That man adores his wife, and his wife is a million times the woman that Blake could ever be in her wildest dreams. When you've got a woman like that, I'm sorry, what is going to appeal to you about Blake? A young idiot man, it's one thing, but a man his age with who's been around, who's had some life experience, they know what they want. And they know what kind of woman is fun and easy to live with. His wife is the cutest, Robin. She's so the cutest. She's sweet. She's not crass. She's not loud. She's not rude. She has a heart. She's hilarious. Yes, she's a lady. She's a million times the actress. A warm and positive person. Exactly. We know what's important to this man. I mean, by his beliefs, by the way he lives his life. It's insane. Ella, thank you so much. Lyman appears to be very pro-plaintiff, and that appears to cloud his judgment. I think he'll deny as untimely or convert to motion for summary judgment. Yeah, that's what I think too, and I hate it. I almost don't even want to listen tomorrow, but I will. And we'll come together and we'll scream together about it. Okay. My favorite thing about the proposal video is that you could tell her patience with his nonsense wasn't tested a bit. She was still locked in at the third musical number. Marry her. Exactly. Exactly. They are relationship goals. They're so sweet. The way that she does something and he just bursts into laughter because he just thinks she's adorable. He can't help himself. It's just like pure laughter that he can't hold back. Indeed, girly. Group therapy session after the hearing tomorrow. I think we'll probably need it. We'll probably need it. Yes. Marry someone who finds you adorable all the time. They're so enchanted with each other. Yeah. You have to be in awe of each other and keep in awe of each other. All right, guys, let me go through and thank everyone again. Thank you, Lil Coco, so much. Thank you, Just Ricardo, and Glow again, and Just Ricardo again, and Glow again, and KKB, and Glow again, and KKB again, and L. And Eliza, thank you so much for becoming a member and reminding me again that I need to do something more for my members. I'm so sorry. When I make stuff, I always want to share it with everybody. I feel mean to just do members, but then I need to do something for my members. So thank you, Eliza, for becoming a member and reminding me I've got to do something for you guys. All right, guys. So stay tuned to that docket. We got big stuff coming, and make sure and go look at Wayfarer's response to the New York Times. I'm sure it's a banger. I've got some errands to run. Maybe back tonight. We'll see how the day goes. Have a great afternoon. Thank you so much for joining.